पुराना चाहिए. Yes, what is the problem with this? Page 26 is incomplete. How is page 26 incomplete?
वहाँ पर 2 से स्टार्ट होता है, 2 से स्टार्ट, पॉइंट 2 से स्टार्ट होता है, जनरली 1 होता है.
Just page number 26.
26.
Where is point number 1?
पॉइंट नंबर 1 रिलेशनशिप पेज नंबर 23 एक बार खोला जाए जहाँ से एनेक्सर 1 शुरू हो रहा है.
हाँ.
वहाँ पॉइंट 1 लिखा ही हुआ नहीं है, ऑफिस ऑर्डर में ही नहीं लिखा हुआ है. वहाँ
25 का पॉइंट 7 पे लिखा होगा, उसके बाद फिर सडनली 2 से
25 में 0.7 होने के बाद फिर एक सिग्नेचर.
हाँ, सिग्नेचर है.
उसके बाद यहाँ पर
प्रतिलिपि शुरू हो गया नीचे.
प्रतिलिपि शुरू होगा. उसके बाद 0.2 कैसे आया? 0.1 कहाँ?
देखिए रिलेशनशिप एक बार पेज 23 खोल लिया जाए.
23.
जो चीज मिसिंग है वही हम बताना चाह रहे हैं.
हाँ.
23 में एनेक्सर 1 शुरू हो रहा है. झारखंड राज्य विद्युत बोर्ड के अधीन जहाँ से सेंटेंस स्टार्ट हो रहा है वहाँ पर
यही एकमात्र
बस
डिफेक्ट है
बस
आपका.
वही, वहाँ कुछ नहीं.
देखिए WPS number 1117 of 2023. The Learned Counsel for the petitioner submits that the office has pointed out a defect that document as page 26 is incomplete. He submits that as per his understanding, the document is complete. The Learned Counsel for the state, state कौन हुआ?
JUVN.
The Learned Counsel for respondent number 2. Who will file this? किसका signature है ये?
ये सिग्नेचर इलेक्ट्रिसिटी बोर्ड के.
The Learned Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case, and the counter affidavit should also include the complete document as contained in Annexure 1 to this writ petition.
इसमें हम एक चीज बोलना चाहेंगे.
अब क्या बोलना है?
इम्प्यूज्ड ऑर्डर एक बार खोल लिया जाए. जो हम क्वेश्चन मांग रहे हैं जिस ऑर्डर का, वो सेम ऑर्डर से सेवरल रिट पिटिशंस मेरे ऑफिस के द्वारा फाइल किया गया है जिससे वेरियस अफेक्टेड थे. डीवी में भी व्हेन योर लॉर्डशिप वाज अ मेंबर ऑफ द बेंच वहाँ भी ये इशू था. वही चीज़ यहाँ भी है. तो मैंने एक लिस्ट तैयार किया है फॉर द कन्वीनियंस ऑफ द बेंच. सेवरल स्कैटर्ड हो गया है रिट पिटिशंस. 6 रिट पिटिशंस हैं. 4-5 में काउंटर आ चुका है. ये काउंटर का ऑर्डर हुआ, आई ने बस टैग कर दिया.
उसमें भी यही डॉक्यूमेंट है?
सेम ऑफिस ऑर्डर. हमको प्रमोशन दिया गया. प्रमोशन के पहले जो इंक्रीमेंट दिया गया था, प्रमोशन देने के बाद 3 इंक्रीमेंट काट दिया गया. रूल 78A1 का जो वायलेशन है वही इशू.
Like the Learned Counsel for the petitioner has also submitted that he has filed the following writ petitions which involves the same point involved in the present case, and in some of the cases counter affidavit has also been filed.
ऑर्डर हुआ है, फाइल नहीं किया.
In some of the cases there is a direction for filing counter affidavit, but counter affidavit has not been filed in any of these cases. ये list है, इसमें डाल दीजिएगा.
All are of 2023.
Was this case on 28th of February 23, along with
लीडरशिप एक वीक बाद कर दिया. 28 आई एम नॉट अवेलेबल. कुछ मेडिकल
काउंटर आएगा तब.
हाँ ठीक.
काउंटर आएगा तो हम आपको टाइम दे देंगे. आप जानते हैं रेस्पोंडेंट कैसे बिहेव करते हैं.
हाँ जी.
The counter affidavit in the present case and also in the aforesaid cases where there has already been a direction to file a counter affidavit be filed latest by 27th of February. Okay.
जी.
All these matters we also posted on the next date, है ना. चलिए आप उसको लेकिन डॉक्यूमेंट लगा दीजिएगा. Let us figure it out whether it's a complete document. Other defects have been removed.
Yes. The defects are. लॉजमा बोर्ड में रिमूव हो गया था. Sold.
Since there are no other surviving defects, No, the defect number 5 as pointed out by the office is ignored for the present.
Admission.
हाँ, under the heading for admission. टैग करके विथ कर देना है सारे केसेस. आप चेक कर लीजिएगा सारे में. ठीक है.
From daily list 215 for admission, item 1 WPS 4741 of the 2023.
Leadership, at the very outset, I would like to state that although there was an order to file a counter affidavit, leadership same has not been filed. We have issued letters to the concerned respondents, leadership, but
He has also filed a supplementary counter affidavit on 31/1/2014. उसका भी रिप्लाई फाइल कर दीजिए साथ में. अलग-अलग ऑर्डर थोड़ी होगा.
Yes, leadership.
आपको कब तक का टाइम लेने के लिए इंस्ट्रक्शन मिला है?
Leadership, I have not received any instructions.
कौन है जिसको आप भेजें और आपसे आपकी बात ही नहीं सुनता है?
So these are the letters which
किसको नाम
to
बताइए? अथॉरिटी.
all the respondents, leadership.
ऐसे आप लोग चिट्ठी लिखते हैं?
Leadership, we send it by soft copy. Leadership. विधि पोर्टल में अपलोड होकर concerned officers डिपार्टमेंट को जाता है.
Who is your disciplinary authority?
To the Director, National Health Mission.
It's a contractual appointment.
Yes.
It was a contractual, but then subsequently by order of a circular, by issuance of a circular, we have been made, given a permanency of tenure up to 60 years. That is in the supplementary affidavit.
So respondent number कौन होंगे? Respondent number 5 will file the counter
Respondent number
affidavit.
3 मिलो,
Mission director.
Mission Director. Full annexure is also issued by the respondent.
The learned counsel for the parties are present. The learned counsel for the by last indulgence हो चुका है.
Yes, leadership.
The learned counsel for the respondents has submitted that in spite of repeated communications with the respondents, no instructions has been received in the present case to file a counter affidavit. He submits that in the meantime, a supplementary affidavit has been filed by the petitioner on 31/1/2024. Since a supplementary counter affidavit has been filed by the petitioner, the same is also required to be responded by the respondents. कितना टाइम आपको चाहिए?
4 weeks time.
आपका इनका फोन नंबर नहीं है आपके पास?
I will.
नहीं, आप फोन करके
Cross-
बताइए क्योंकि अगला डेट में उनका पर्सनल अपीयरेंस कराएंगे ना.
Leadership, I will cross
नहीं,
verify.
नहीं, आप बाहर जाइए, उनसे फोन पे बात करिए कितना टाइम चाहिए, राइट?
Yes, leadership.
Failing which he will appear in person with all the records. We will see the records and pass the order. We will not require a counter affidavit.
Short password. Leadership.
On instructions, the learned counsel for the respondents has submitted that time till एक tentative बता रहे हैं, ठीक है? 29th February be granted to file a consolidated reply to the main writ petition as well as to the supplementary affidavit. Although by order dated 18/12/23 by way of last indulgence, the matter was adjourned to enable to file counter affidavit. But in view of the supplementary affidavit filed by the petitioner, time till 29 February is granted, pose this case on 4th of March. If the counter affidavit is not filed within the stipulated time, the respondent number 3 shall appear in person with all the connected files for perusal of this court and will assist the respondents for the disposal of the matter. चेक करके बताइए.
Violation item 2, WPS 3 of 2023.
Well, this case petitioners, petitioner put it, even petitioners also they have paid for promotion on the post of sub-divisional audit officer also.
They have filed a counter affidavit
They have
that their
filed
case
their
will be considered in
in
DPC.
paragraph 8 and 12.
Yes.
Paragraph 8 they have admitted lordship.
Therefore, the writ petition can be disposed of. Now they are in the process of consideration. You
And
considering
paragraph
the
12 they have also paid to be disclosed by fixing a date.
date हमने हासिल की.
नहीं टाइम तो दीजिएगा ना.
Not necessary.
But the
We
kindly
will not give any time.
But the kindly the Department of Personnel has issued a letter by fixing the Kalavdhi laws. In this same letter, it has been clearly mentioned that राज्य के विभिन्न विभागों प्रशासनिक नियंत्रणाधीन सभी संवर्गों और प्रोन्नति के रिक्त पदों के विरुद्ध हड़ताल प्राप्त कर्मियों की प्रोन्नति की तुरंत कार्रवाई की जाए. इसके लिए वर्ष में कम से कम 2 बार विभागीय प्रोन्नति समिति की बैठक अवश्य आयोजित की.
कब से नहीं हुआ?
मतलब they are entitled of being promoted.
Since when they have not? This DPC has not been held.
From last 10 years,
Where have you stated?
I have not stated lordship, but my submission is lordship that these petitioners have these petitioners joined in the year 2011. Within 5 years, there is a Kalavdhi of 5 years, which they have completed for promotion of the sub-divisional audit officer. The said 5 years have completed in the year 2016, and now it is at 2024.
Just how much
They have-
time will it take to do the needful?
Lords, that has to be ascertained by the department concerned. In the
We are
meanwhile,
at your mercy.
no, my lords, absolutely not.
You have issued your own circular that at least twice DPC should be held in a year.
We have brought it on, stated in our counter also. my
That's
lord.
fine. But it is your own circular. No, कहाँ है circular?
Lordship, annexure 4 page 59. नियम से हजूर हमको थर्ड प्रमोशन मिल जाना चाहिए था अगर टाइमली चलते गए.
For that, my ladyship, we have recommended their
Page 59 lordship.
recommended their case for ACP and MSCP in the meanwhile, my ladyship.
There's no.
Have you done a mercy to them?
No, definitely not. my lordship. Just-
MSCP and ACP, are there a substitute of a promotion?
No, definitely not. They
Then?
cannot be. For that, my ladyship, we have stated that DPC is going to be.
Page 59 lordship.
And
Page 15 next page 60 Roman 1. राज्य के विभिन्न विभागों के प्रशासनिक नियंत्रण सभी सेवाओं में प्रोन्नति के रिक्त पदों के विरुद्ध अर्हता प्राप्त कर्मियों के प्रोन्नति की त्वरित कार्रवाई की जाए. इसके लिए वर्ष में कम से कम 2 बार विभागीय प्रोन्नति समिति की बैठक.
And when was the counter affidavit filed?
The counter affidavit
17/1/2024.
I have received on 18th January 2020.
Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioners were inducted, were appointed on the post of senior accounts officer,
Senior auditors.
Senior Audit Officer on the recommendation of JPSC, Jharkhand Public Service Commission, pursuant to competitive exam conducted in terms of advertisement number 16 of 2008. And after completion of the required training, they were all working on the post of Senior Audit Officer in the year 2011. The learned counsel submits that upon completion of 5 years, their case was due for consideration for promotion, but the same has not been considered so far, which has compelled the petitioner to move this writ application. The learned counsel has also submitted that though a counter affidavit has been filed on behalf of respondent number 1 to 3, stating that DPC will be held, but neither any time frame neither any date nor any time frame has been mentioned therein. the learned counsel submits that in view of he has also referred to gazette notification of
Yes.
the state of Jharkhand dated 4th of April 2014 and has referred to clause Roman 1 thereof to submit that the various authorities of the state are duty bound to conduct meeting of departmental promotion committee at least twice a year. The learned counsel has submitted that in spite of taking a policy decision to that effect, the respondents are not following the same and the counter affidavit is totally vague in connection with the holding of departmental proceeding, meeting of departmental promotion committee. And in this background, he submits that some time frame may be given so that the legitimate rights of the petitioner be not defeated. The learned counsel appearing on behalf of the respondents has submitted that the respondents are taking steps, but he is completely clueless as to why the decision of the state government as contained in the notification dated 4th of April 2014 is not being followed by the state. The learned counsel submits that on account of non-grant of promotion, ACP and MACP is being provided to the petitioners. However, it is not in dispute that ACP and MACP by themselves are not substitute of promotion.
In the meanwhile, my lords, the posts have also been earmarked. The 35 posts have been earmarked, which are vacant for the promotion of district accounts officers, subordinate accounts
He
officers.
has submitted that the post to be filled up through promotion has already been earmarked. Right? That's it.
Right.
After hearing the learned counsel for the parties and considering the materials brought on record, it appears that the petitioners have been working on the post of senior audit officer and their promotion is due for quite some time. The respondents have not acted in terms of their own policy decision as contained in clause within bracket Roman 1 of the notification dated 4th of April 2014. Clause Roman 1 is quoted as under page 61 mein Roman 1. As per the counter affidavit, the respondent number 1 to 3 have made following inter alia following statement in paragraph 8 and 12. Quote कर दीजिएगा.
7.
7, 8 and 12.
7 में दिए हैं लोग कि कितना वैकेंट पोस्ट
7, 8 and 12. Thus, the entitlement of the petitioners for consideration in the departmental promotion committee, if they are otherwise entitled upon verification of their records, is not in dispute. However, the matter regarding their promotion has been kept pending for which no reason has been disclosed in the counter affidavit. In view of the fact that the respondents have acted against their own policy, this court is of the considered view that appropriate direction is required to be issued so that the respondents would expedite the matter regarding consideration of promotion of the petitioners by conducting departmental promotion committee meeting. Accordingly, this petition is disposed of. Who would be directed?
The respondent number 1 was secretary.
By-
Respondent 2, sorry.
By directing the respondent number 2 to promptly conduct the meeting of Departmental Promotion Committee so that the claim of promotion of all eligible candidates, including the petitioners, in case there is no other legal impediment, so far as in case there is no other legal impediment, be considered and appropriate, and the meeting be convened not later than within a period of 3 months from the date of communication of this order. This court has not gone into the entitlement of the petitioners for promotion. Their claim will be subject to all applicable rules, guidelines.
Item 3, WPS 6 of 2023.
Yes, petitioner.
Yes, Your Worship. This is 4.
The session is over.
Session is already over, Your Worship, and on the last occasion, Your Worship has directed them to file a counter. Your Worship, in
So
fact,
when the sessions is over,
Your Worship,
what relief can be granted to you?
Worship,
This case has become infructuous.
I have placed one, Your Worship, instance.
That is not sufficient. We are not inclined to grant any such. It is all inductions are through very tough competition.
Therefore, Your Worship, I have completed through that.
You have
selection
completed, you were not well for some time.
Your Worship, they have not granted me the NOC. Now they are saying
No.
The state
You yourself were not well for some time.
thereafter, Your Worship.
You see, the fact remains that during the session in question, you have not studied. We cannot adjust you against any other session.
No, Your Worship, I am not on that. I am only saying, let them decide my representation.
No.
They are-
You
I don't
withdraw your
think-
petition and you do whatever you want to. I will not issue a direction for consideration of your representation
Your
when the
Worship,
session is already over.
in that case, I will do.
WPS number 6 of 2023. After some arguments, the counsel for the
Your Worship, I will
petitioner,
not press that.
counsel for the petitioner
On instruction of.
on instructions does not want to press district petition. Accordingly, district petition is dismissed as not pressed. Prayer court कर दीजिएगा.
साइन कर दीजिए सर.
Item 4, WPS 9 of 2023.
Petitioners are the selected candidate of Homeguard as in view of advertisement number 1 of 2016, Lordship. In this matter, Lordship, thrice results were published, and for the fourth and document verification of all the petitioners were done. They are waiting for their training. In the meantime,
You have been declared successful.
and 3 times results were declared and petitioners were declared successful.
They are waiting
And
for training.
Their document verification has been completed. Police verification.
Appointment
has
letter
also-
has been issued.
No, appointment letter has not been issued. In the meantime, one fresh list has been published in the year 2022, December 2022, and in that list, some new persons were inducted and petitioners' name were left over. And without cancelling previous results, Lordship, for the fourth time, they have published the result. And
Now
in the
those persons whose name has been inducted,
their roll number has been inducted, no merit list has yet been issued by the respondents. Merit list is not there, only newspaper has been published mentioning their in roll number.
you have challenged that publication of result also.
We don't know who are those persons, there is no list. How we
RTI नहीं है क्या आपके पास?
RTI तो यहाँ मैडम वैकेंट है स्टेट एजेंसी और कभी मिलता नहीं है हम. And
We cannot enter into roving inquiries.
in the counter affidavit also they have not denied me our statement. Not a single statement has been
You have to
denied.
make out a case from your date petition, not your counter affidavit.
No, I am
What
making
is the
out
stand
my.
in the counter affidavit?
Your Ladyship, as per the total number of vacancies, there were 771. Rural was 362 and urban was 409. And only and earlier selected candidates was 1029, for which it was reduced to 771. We have mentioned in counter affidavit para 14, page 17, your ladyship, where we have some of the merit list who were in the bottom, it were excluded, your ladyship. For that reason only, for the technical candidate who were selected on the basis of NCC and sports quota, it has been seen, and for that he has been, your ladyship, his name.
Now
is in the bottom.
their name is not appearing for that reason.
Yes, your ladyship, for the
How do you
number
say?
of,
How do you induct new persons in the merit list?
your ladyship, for the total number of, and after that we have seen that it can be reduced, it will be reduced to 771, as we have seen in the urban and the rural, that total number.
That
count.
segregation has to be there.
Yes, your ladyship, for the bottom line, and it has been before the deputy commissioner, it was recommended to see the before the training only documents to be verified, and for the quota and the NCC.
All the selected candidates ultimately, whomsoever you have ultimately selected, appointment letters have been issued to them.
It has been completed, your ladyship.
The selection process is complete.
It has not been mentioned, your ladyship, but as per my knowledge.
Knowledge से नहीं चलता, counter से चलता.
It has been completed.
In the interlocutory
Please.
application, I have filed one interlocutory application, Lordship, wherein I have challenged the decision taken by the respondent number 3 regarding the
First
sending
we
of
see
persons.
the more age, your lordship, and provisional merit list. Annexed, your lordship, ladyship.
How many petitioners are there?
There are 47 petitions.
47 petitioners. एक-एक का कहानी बताइए.
एक-एक का कहानी
एक-एक का कहानी
हाँ, एक-एक
बताइए.
का कहानी एक्सप्लेन किए हैं.
ये जो है ना एक साथ जो आप लोग रिट पिटीशन फाइल कर देते हैं और सबका एक जैसा ऑर्डर हो जाता है, ये हमको नहीं समझ में
मैंने
आता.
एक-एक का एक्सप्लेन किए हैं.
Individually we have to see, your ladyship, whether.
No, individually I have stated in paragraph 20, 21, 23. And there are 1098 vacancies.
वैकेंसी कुछ नहीं होगा. एडवर्टाइज था ओनली 771.
नहीं एडवर्टीजमेंट में तो वैकेंसी का वो जिस बेसिस पर था, ऑन द बेसिस आई हैव फाइल्ड द रिजॉइंडर एफिडेविट ब्रिंगिंग ऑन रिकॉर्ड द लेटर ऑफ ईयर 2019 कि उसके बेसिस पर वहाँ था 1098 वैकेंसी आर देयर. आई हैव ऑलरेडी प्लेस्ड ऑन रिकॉर्ड बाय वे ऑफ रिजॉइंडर.
2019 में the advertisement is of the year 2016.
हाँ,
उस दिन
लेकिन-
कितना वैकेंसी था? How many vacancy was there in 2016? We are concerned with the vacancy in the year 2016.
1090.
1098.
हाँ, 1098.
Vacancy in 2016.
हाँ, 2016 में.
Show me that letter. That in 2016 there was 1098.
I am placing my rejoinder. Rejoinder, annexure 1.
In rejoinder, you bring on fresh documents. Were you not aware of this document when you filed the writ petition?
They have subsequently taken a stand that now the vacancy has been reduced. In the paper publication or in the result they have published, they have never reiterated these facts. Therefore,
Where is it that the vacancy was 1098?
yes, Lord.
Show me.
महानिदेशक सह I am placing annexure 1 to my rejoinder, page 11. Last fourth line, page 11 of my rejoinder. Last fifth line. महानिदेशक सह महासमादेष्टा गृह रक्षा वाहिनी एवं अग्निशमन सेवा झारखंड रांची के ज्ञापन 188 दिनांक 30/1/2017 के द्वारा पूर्व से स्वीकृत 14 प्रखंड 110 1540 को बढ़ाकर 18 प्रखंड गुने 110 1980 करने के साथ शहरी इकाई में पूर्व से स्वीकृत कोटा 1120 को बढ़ाकर 1257 कर दिया गया. इस प्रकार ग्रामीण बल के अंतर्गत 440 एवं शहरी बल के अंतर्गत 137 गृह रक्षक बल की बढ़ोतरी हो गई। रिक्तियों में बढ़ोतरी के कारण विज्ञापन संख्या 1/2016 में प्रकाशित की गई रिक्ति 771 के विरुद्ध ग्रामीण 528।
ये तो नहीं हो सकता ना। The vacancy will be seen on the date of advertisement.
ठीक है, ये मेरा आर्गुमेंट भी नहीं है। मेरा आर्गुमेंट ये है for the three results they have petitioners were declared successful, the result is still not cancelled and they have published new result. Our result has never been cancelled. एक लेटर भी नहीं है पूरे काउंटर एफिडेविट में कि हमने इनका सिलेक्शन कैंसिल कर दिया और इस कारण से कैंसिल कर दिया। For the 3 times the petitioners were declared successful. और काउंटर एफिडेविट में मेरा एक सिंगल स्टेटमेंट।
Where are those results by which you were declared successful? Show me all the results. I want to see all the results and with the date.
Yes, sir. I have already annexed all the results.
Yes. Tell us. When was the first result declared?
Yes, Lord. The first result was published on 9th of March 2018.
9
March
2018.
Lords.
Where is that annexure?
Annexure 1 is annexure 2 to supplementary affidavit.
Supplementary affidavit.
उसका
Supplementary affidavit का तो ये लोग reply नहीं फाइल किए ना?
नहीं,
Read petition का फाइल.
immediate हम फाइल कर दिए supplementary affidavit.
So, without seeking leave of the court, you will file supplementary affidavit.
Immediately because of the reason
Is it your right?
in the read petition.
Is that your right?
In the read petition, Lordship, I have stated that the petitioner will carve leave of the honorable court to present those documents which are relevant at the time of hearing. Just after filing of read petition, when number has
Without leave, you have filed it. You said that you will take the leave of the court and file it.
No, I will produce with the leave of the honorable court. I have said immediately.
They have not responded to your supplementary counter affidavit. Have you?
I have already served. Immediately I have served. Immediately I have served to them before the first hearing of the before the honorable court. The supplementary affidavit was already on record on that day. Eligible उतना नहीं था, डिफेक्ट में कभी भी क्योर नहीं होता, इसलिए ऐसा करना पड़ता है।
Illegible documents कोर्ट के माथा में डाल.
Ineligible जो डॉक्यूमेंट नहीं था, लेकिन कंप्लीट नहीं था. The paper was not complete. Therefore, I have been on record by way of supplementary. It is public document. It is newspaper. Thereafter, second result was published on 8th of September 2018.
Where is your supplementary affidavit?
Yes.
And where is the result?
Page 56 and page 57 of my supplementary affidavit.
Annexure A does not have a date.
No, Hindustan, 9th of March 2018. Hindustan newspaper.
And next?
Next is already on record in read petition. 9th of September 2018, Annexure 2. Thereafter, third result was published on 14th of April 2022, Annexure 4. In all these 3 results, the petitioners were declared successful.
Why 3 results were published?
The reason is best known to respondents. They have, without any reason, they have published one list, second list, third list.
It is one thing to say that there are 3 different lists. It is another thing to say
that
three
times results were published for the same region, for the same candidates. For the regions, the candidates were not known.
Okay.
For the fourth time, they have published.
What is the date?
Result, on 27th of December 2022, for the first time, by way of Annexure 5, I have already bring on record.
So this is under challenge.
This is under challenge. Annexure 5. It is also a paper publication on 27th of December 2022. page 121.
That particular declaration of result is not under challenge. You say that the persons who have secured less marks than you have been selected.
The persons who were selected, their roll number has only been mentioned.
And you say that you who have secured less marks than you.
Because of the
From where do you say that they have secured less
the,
marks than you?
on the ground that they have not been deducted in first list, second list, or third list. Their name was not there. Subsequently, their
Which all are the roll number whose name did not figure in the first, second, and third list? Show me the roll numbers. Which all are the roll numbers whose name did not figure?
All the roll numbers which were mentioned in Annexure 5 were not mentioned in Annexure.
All of them?
All of them. All of them.
From where do you say? Is it completely new list?
It is completely new list. On the basis of my scrutiny, I am submitting before Lordship.
Your scrutiny as a counsel or your scrutiny as a client?
No, my scrutiny as a counsel.
We are not concerned with your scrutiny. What is the instructions from your client? What is your case?
My case is that we have qualified in all three lists. Our name has been published by the respondents. Thereafter, document verification of the petitioners were completed. Police verification of all the petitioners were completed. They are waiting for sending them to training. In the meantime, one press list has been published in the newspaper mentioning the roll numbers wherein the petitioner's roll number has not been find place. And our statement with respect to paragraph 20 to 24 with respect to malafide has not been denied by the respondents in single statement.
What malafide?
Malafide with respect to malpractice, because the person
who is the person by name? This case kare. Malpractice, when you say malpractice, then the state is not undertaking any malpractice. You have to name the person. That such and such person has entered into malpractice and therefore he has been made party by name. Malafide ka allegation cannot be taken so lightly that you will make an allegation of malpractice. Right?
And I will implead in party.
You file another writ petition.
Lordship,
yes, what is your case? There are three lists. You publish a fourth list. What is your explanation for the fourth list?
For fourth list, Your Lordship, first of all, the verification for the entire process, it has been started. That the number of candidates, we have mentioned in para 9 for that.
We do not know. You just tell us. You read your counter affidavit yourself. You tell us that what was the occasion you published the fourth list.
Your Ladyship, for the age purpose, it has been verified that how much marks they have secured, what is the age, the bottom
He
list.
says that the name of persons in the fourth list was not there in first, second, and third list. Is that correct?
No, Your Ladyship, nowhere it has been mentioned in the writ also. That
You say that fourth list has been published after verification. So
After
his marks etc. must have been verified then.
Yes, Your Ladyship.
Where do you say that that the credentials of all these petitioners were verified and they were not found suitable?
Your Ladyship, there the technical female and technical male, in that criteria it has been seen that how much they have secured marks, the age, everything, and the rural and the urban area. For that verification, after verifying of all the documents, it has been published, Your Ladyship.
By the petition of the sentence that does not serve the purpose. Have you said that the list which was published on all the three earlier occasions were incorrect? Then,
that it has been incorrect.
if it is incorrect, then why do you need to publish the fourth list?
According to the marks, those who were disqualified, after that only we have published the final list, Your Ladyship.
Those who have disqualified after upon verification.
After
Those who were disqualified after verification of the documents.
After not verification, we have seen all the criteria to be fulfilled, Your Ladyship.
No, what criteria? You see, you call them for verification. You did the needful. They have been declared unsuccessful.
Yes, Your Ladyship. That's
Where do you
clear.
say that they have been declared unsuccessful?
Your Ladyship, in para 14 I have mentioned.
That they were called for verification and they
Conducting
participated.
technical test whereby 30 is the qualifying marks and 18 that person have less marks. I have mentioned
Para number?
Page 18, para 14 of the counter affidavit.
Page
Your
16.
Ladyship.
Peज 16.
हाँ 16 से start हो रहा है 18 I'm reading 18.
आप नहीं इंटरप्ट करिए.
नहीं इंटरप्ट नहीं कर रहे हैं.
आप बैठ जाइए प्लीज.
It was further found that whether in the
Will you take your seat?
Yes, Lord.
Please sit down.
it has been seen in the merit list that whether the person who have been selected that the mobile repairer, tailor, beautician can be considered the technical qualification or not in the annexure
Let
J
us see.
of page.
Please place your contract.
Ladyship, para 14,
Para 14.
14, page 16
Yes.
has been started here, Ladyship. The objections which has been raised here, Ladyship.
All right. Kindly read it.
It was recommended that before training
You
documents,
please read it right from para 14.
that total 220 objections were received and several objections were also received online. And all the objections were verified and a report dated 19/11/22 to that effect was submitted before the Deputy Commissioner whereby it was recommended that before training documents of the selected candidates should be verified in light of memo number 150 dated 18/1/22. Earlier selected candidates, that is 1029, were reduced to 771, and earlier selected candidates who are at the bottom of the merit list, published by the commandant, were excluded. It was further found that the persons who were selected on the basis of NCC and sports in technical category, both male and female, whether they can be considered as technical qualified in view of the Rule 4 Note 2 of the Home Guard Rule 2014, that Rule 4 Note 17 provide for conducting technical test whereby 30 is the qualifying marks and Note 18 provide that person having less marks than 30 will be held disqualified. And the committee found that in provisional merit list, names of some persons were found whose marks were less than 30 in technical field, which itself is the criteria for disqualification. It was further found that whether in the provisional merit list, the persons who were selected having knowledge of painter, mobile repairer, tailor, and beautician can be considered as technical qualification or not is a policy decision. Annexure J, Your Ladyship, that is page 67. His name was there, Anuj Kumar Sinha, ये श्री नागेंद्र प्रसाद, क्वार्टर नंबर इतना, रुलवा का मेधा सूची में तकनीकी अंकित है, परंतु क्या तकनीकी है इनका उल्लेख नहीं है. And further, next para, Your Ladyship, we have certain relevant directions was also enumerated. That is, the documents of all the selected candidates after enrollment should be verified, and from provisional merit list, and they got less than 30, which was earlier I have mentioned in the para, Your Ladyship.
Where have you stated that that all these petitioners got less marks upon verification?
We have not mentioned that, but preference will be given to the person more age and provisional merit list will be modified to that effect. That we have mentioned in para I in page 27.
What technical qualification do you have for each of the petitioners? अब क्या technical qualification है आपके पास? Each of the petitioners, what technical qualification do they have?
Yes, Lord. I am replying. In the supplementary affidavit, Lordship, I have bring on record the admit card of each of the petitioner.
Technical qualification is mentioned in the admit card?
No,
I want to know because certain technical qualification was also required. What technical qualification do you have?
Yes, Lord. In paragraph 23, stated it with respect to each of the petitioner. The petitioner number 1, having roll number so and so, applied for urban for the post of driver. The petitioner number 2, petitioner number 1 has been declared successful in first and second list. Thereafter, the petitioner number 2, having roll number so and so, I am placing page 35 of my petition. Paragraph 23. Petitioner number 2 applied for
Driver is a technical qualification?
yes, Lord, as per advertisement.
Alright, next.
Thereafter, the petitioner number 2, non-technical, he has applied for non-technical. The petitioner number 2 has been declared successful in first and second list, and his document verification was done and recommended. The petitioner number 3, having roll number so and so, applied for.
So non-technical have as it is out, isn't it?
Some of the petitioners are technical, some of the petitioners are non-technical.
Non-technical.
Each and individual case of the petitioner has been explained in paragraph 23 onwards with respect to each of the candidate lordship. And the respondents in counter affidavit.
Where you called for your verification? Where you called for your verification?
Lordship.
Where all of you called for verification?
Jeff Brown.
You were all called for verification.
Lordship.
Madam, you see, para number 23 give the details. इनका roll number कौन सा है? What is their roll number? Where is it mentioned?
In paragraph 23.
Roll number is अच्छा roll number भी mentioned.
Roll number के साथ.
Okay.
Technical,
Madam, you do one
non-technical.
thing. Right, you give the cutoff marks. Right, and all these persons individual verification marks. What is your response to para number 23? Have you specifically responded to para number 23?
Of supplementary
In the
Of main writ. Of the main writ. You have not given para-wise reply. You respond to para number 23. They have given all the details, give their marks. Put it
all
on
the
record.
petitioners' marks.
All the petitioners' marks, prepare a chart, what all technical qualification they have, right? Somebody may be a cook, somebody may be a beautician, we do not know, right? And whether that will come under technical qualification or not, because there is a dispute regarding that also, right? Whether a particular qualification will come under technical qualification or not, right? And then you give the marks of each of the candidates, whatever they have obtained, and in their category, what is the cutoff marks, and whether they had applied under rural or urban category. There were two different applications.
Two different categories. One is rural and one
Yes,
is
so
urban.
you have to categorize that also.
And
Right?
one more submission, Lordship. One more submission. The respondents may be directed to bring on record the entire merit list.
आपसे आपके कहने से नहीं होगा ना?
नहीं
आपको तो खुद ही नहीं पता आपका केस क्या है.
नहीं मेरा तो केस यही है कि 3.
They will not bring it on record. Why should they bring it on record? They will give you the cutoff marks. They will give you your marks also. That should be sufficient for you.
The persons who were selected
It
must
will
be
be clear that how much they have secured and whether
Yes.
eligible or
The
not.
cutoff marks, how much they have secured, whether their candidature has been considered under rural or urban category. In their category, there could be reservation also for reserved category. So all the cutoff marks, reserved categories, male, female, whatever. Right?
Indeed.
Okay, counsel for the parties are present, though a counter affidavit has been filed in the present case, but no para-wise comment has been filed. The learned counsel for the petitioner has submitted that the required details of each and every candidate has been mentioned in para number 23 of the writ petition. The learned counsel for the respondents is directed to seek instructions with specific reference to para number 23 of the writ petition, giving the details of the marks and the learned counsel for the petitioner has also submitted that the petitioners, that all the petitioners had duly participated when they were called for verification of their credentials. He also submits that, however, the marks obtained by them is not known to the petitioners. The learned counsel for the respondents is directed to seek instructions and file a supplementary counter affidavit in the present case with specific reference to para number 23 of the writ petition. She is also directed to indicate the cutoff marks in the category in which the candidature of each of the petitioner has been considered. Their technical qualification, if any. That should be sufficient. And any further detail, any further information which may be relevant for the disposal of the present case. How much time do you need?
3 weeks.
Let this matter be listed on (27th of February 24). The supplementary counter affidavit should be filed by 23rd February.
उसके बाद हमको रिजॉइंडर फाइल करने के लिए थोड़ा टाइम दे दिया जाता है।
जब मार्क्स आ जाएगा तो उसका क्या रिजॉइंडर फाइल करेंगे?
देख लेते हैं, अगर जरूरत पड़ेगा तभी फाइल करेंगे, नहीं तो नहीं फाइल करेंगे। इसलिए
आने तो दीजिए ना, अभी आपको लगता है आ जाएगा 3 हफ्ता में? जब तक पर्सनल अपियरेंस नहीं करेंगे कुछ नहीं आने वाला।
चौक से आना है, आ जाएगा, क्योंकि इसमें कुछ गड़बड़ बहुत मोटा हुआ है ना, इसलिए आ जाएगा, तुरंत रिस्पांस आ जाएगा। इसलिए
हम लोग रिकॉर्ड से चलते हैं, आपके सबमिशन से नहीं चलते।
आफ्टर 1 वीक
we will go strictly by the records.
आफ्टर 1 वीक रिजॉइंडर एफिडेविट के बाद
let the counter affidavit come, we'll see.
अब उस दिन क्या इंडिकेट तो कर दिया जाएगा।
उस दिन हम रहे ना रहे हमको तो नहीं पता।
नहीं तो उस दिन तो ये होगा कि
let them file the counter affidavit, we will see the counter affidavit. If there is a prayer,
लिबर्टी में भी गिवन टू
liberty is always there to file the rejoinder.
तो टाइम मिलेगा तब ना, इनको डेट कर दी, उसके बाद नेक्स्ट डेट
इतना तो
फिक्स हो
हर
गया।
केस में टाइम मांगते हैं।
नहीं हम क्यों टाइम मांगेंगे, हम टाइम मांग ही नहीं रहे, लेकिन जब काउंटर एफिडेविट सप्लीमेंट्री काउंटर आ जाएगा तो उसके लिए 1 हफ्ता तो टाइम चाहिए।
अरे let them file it first, let it come on record, we'll see. You pray for time, we'll give you time.
उस दिन मिलेगा नहीं मिलेगा, इसीलिए कह रहे हैं लॉर्डशिप कि हमको रिजॉइंडर के लिए टाइम इंडिकेट कर
इतना एंटिसिपेशन में हम लोग नहीं चलते। आपको बाहर जाना है?
नहीं हमको कहीं
कोर्ट में है ना?
हाँ।
बस ठीक है, आ जाइएगा उस दिन।
Item 5 to LPS 32 of 2023.
Leadership is serial number 1 leadership, serial number 1 leadership, in which I was directed to take instruction from respondents that what time the counter affidavit will be filed.
Yes.
Leadership, I have talked with mission director, that is respondent number 3, who is the concerned officer. He has ensured that counter affidavit will
Within the time which we
yes,
have
yes, it will be.
वही रहेगा, है ना? कौन लिया था डिक्टेशन? सौरभ को बोल दीजिएगा, सीरियल नंबर 1 में जो ऑर्डर हुआ था वही रहेगा। इसमें क्या है?
This matter relates to regularization also.
What regularization?
Petitioners who are teaching and non-teaching employer. KKM College Jharkhand, which is constituent college to Sidhu Kanu Murmu University. Their services have been duly approved by the Jharkhand Academy Council University. And they have
Where is your appointment letter?
that is
How many petitioners are there?
6 years, altogether 6. Annexure 1 kind
Your matter was before the Agarwal Commission?
No. They are intermediate colleges.
Oh,
Not university colleges.
okay.
Preliminary objection is there, Lordship, which the petitioner has also stated in paragraph number 27. As the petitioners are employees of the intermediate college, so the case should be filed before the JT, Lordship. At that moment of time, JT was not functional. He has stated that at that moment of time, JT was not functional. Now JT is functional. And Mr. Sudeep Prasad is the chairman of JT, Lordship.
Go to JT.
Paragraph 27, Lordship. because
Para 27 of the writ petition.
he himself he has stated that because jet is not functional, so he has moved before this court. Because I usually take this preliminary objection on
That's
the
right.
Actually, what I have
You go.
some,
So
there was an interim order, Your Worship. Time and again they have been granted time for filing
That's
counter.
right. Now, no
Now they
counters.
have chooses not to file any counter and oral objection.
No, you go to jet. You yourself say it was non-functional. Now it has become functional. You go to jet for your relief. So many things are required to be seen.
There's only
WPS
one
number
prayer,
32 of 23.
Only one small prayer, Your Worship. There is an interim order that. if the
Interim
wit-
order cannot continue.
No, I am only praying, Your Worship, till my case was heard with the judge, Your Worship.
No,
Only
we
till
will
that.
not extend.
Because Your Worship,
You have
went
not
about
seen
to-
the recent judgments. Extending of interim order at a time of disposal of a case is not proper unless there are compelling circumstances to do so.
Early hearing का direction कौन सा देगा?
आप फाइल ही नहीं की अभी
हम
तक.
फाइल कर देंगे
हाँ तो करिए. WPS number 32 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has referred to paragraph 27 of the writ petition to submit that the petitioner has himself submitted that that the relief that Jharkhand Education Tribunal has a necessary jurisdiction to grant the relief, but at that point of time, but instead he has filed the writ petition before this court. The learned counsel has submitted that as on date, the Jharkhand Education Tribunal is fully functional, and therefore the petitioner may be delegated to avail the alternative remedy.
So there are judgments that once the case is admitted, Your Worship, the question of maintainability cannot be.
It has been admitted.
But your counter has been directed.
That
Your
is not
Worship.
sufficient.
And there is an interim order, Your Worship.
At this, the learned counsel for the petitioner has submitted that there is an interim relief granted in favor of the petitioner, and
And jet was not functional.
at the time of filing of the writ petition, the jet was not functional. After hearing the learned counsel for the parties and considering the facts and circumstances of this case and the facts and circumstances of this case and the fact that Jharkhand Education Tribunal is now functional, this court is not inclined to proceed any further in the present writ petition. Accordingly, this writ petition is disposed of, enabling the petitioners to approach Jharkhand Education Tribunal within a period of 15 days from today. If the petitioner so approaches Jharkhand Education Tribunal, the case be taken up on merits and be decided expeditiously. This writ petition is disposed of.
Item 6, WBS 34 of 2023.
Yes, petitioner.
This petition has been filed for direction of the concerned respondent to pay the amount of revenue of the petitioner from the period between 22nd of September 2017 to 13th of October 2019.
To 13th October.
Yes, ma'am, 2019.
Honorarium for what?
Petitioner is Malad Anganwadi Sevika.
She was terminated, my lords, during that day.
When was she terminated?
Malad, I'm pleased. Malad, by direction 1 at page 16 on 22nd of 9, 2017. 22nd of September 2017, by letter number 193 of 193, the services of the petitioner has been terminated. Page 16 may kindly listen.
That's right, I've seen it.
Now, thereafter, petitioner has approached the school in WPS number 7416 of 2017.
Yes, then what happened?
It starts from page 17, madam. Although the relevant portion is at page 20.
Yes. Then what happened?
Madam, the order was set aside. My lord, may I read, my lord, two paragraphs from the bottom, second and third paragraph, my lord. As a cumulative effect of the aforesaid rules and guidelines, I hereby quash the order as contained in memo number such and such dated by 2017.
Fresh proceeding was initiated. Fresh proceeding was initiated.
My lord, counter has not come.
Yes, my lord.
Counter has not
You
come.
must be knowing whether fresh proceeding was initiated against you or not.
My lord, yes, after the
After
quashment,
this order.
after the quashment of the impugned order, my lord,
Yes.
the petitioner joined her services on 15/10/2019. She was allowed to join the post. Letter has been issued for joining on 14/10/2019,
Okay.
and upon the same, petitioner has joined on 15/10/2019. My lord, only my lord, my honorarium has not been given, despite of the fact that this honorable court, while disposing of the writ application, has indicated in the order that the petitioner petitioner has been reinstated from the date of passing of the impugned order. Page 20 is there. Page 20. As a result of quashment of order, I am reading, my lord, the third paragraph, my lord, from the bottom, from third line. As a result of quashment of order, I direct the respondent to reinstate the petitioner from the date of passing of the order restraining the petitioner from discharging the duties. Despite of the same, my lord?
Page number 20.
Yes, my lord.
As a cumulative effect of the
Yes, उसी में जो है वो जो हम तीसरा लाइन पढ़ेंगे. As a result.
Have you initiated fresh proceedings or not?
But the counter is not there.
Why have you not filed a contract?
But I have received instruction about
What instructions have you received?
but they are not going to consider the case of the petitioner.
You might not have worked during this period.
Yes, ma'am.
My lord.
Did you work during this period?
My lord, I was restraining from the.
At the time of setting aside the order by this court, was there any direction for payment of back wages?
No, my lord, that was open for the petitioner. That's why, my lord,
Where
this
is
line
it
has been
open
on,
for the?
on
Where
my,
is it open for the petitioner in the order?
my lord, on my on the basis of my argument, my lord, this line has come, my lord, that the respondents have been directed to reinstate the petitioner from the date of restraining of the petitioner from her work. So, my lord, they are finding that the
But the court
order
has not.
impugned
But the
order.
court has not directed for grant of wages for that period. Were you not?
My lord, the petitioner is not a wrongdoer. My lord, he was restraining by an illegal order. That's why this court has interfered in the order.
That's right, but has not given you back wages.
My lord, that's true that it has not come, my lord, and it was not paid by the petitioner at the time of filing of the writ petition. Only the petitioner has prayed and challenged the order of impugned order which was given to the petitioner and terminated the job of the petitioner. Now the order has been set aside, finding that the order impugned was illegal. So, my lord, the illegal on the basis of an illegal order, petitioner was restraining from the job.
So you will come again for back wages. You will not have consequential relief in the writ petition itself.
Lord,
Are you not supposed to pay for consequential relief in the writ petition itself?
Consequential relief, my lord, meaning there, my lord, that the petitioner has been, that's why petitioner has been allowed to join her services from the date of passing the impugned order, my lord. By which, my lord, the services of the petitioner have been terminated. Let them file their response, madam.
Nothing is required.
Since my lord, the order is very clear, madam. The authority who has issued the impugned order, she was not authorized under the law to
Who is Deputy Commissioner of which district?
law.
According to you, no fresh proceeding has been initiated
I will
against you.
take instruction from you.
Why do you need to take instructions when there is an order of the writ court that fresh proceeding
My
will
lord,
be initiated?
sometime-
Will you not take instructions at the time of filing of the writ petition?
My lord, sometimes they started for proceeding, sometimes they do not, my lord. That's why, my lord, I have to take instruction. I have only been instructed to file this case for that intervening period.
देखिए WPS number 34 of 2023. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was working as Anganwadi Sevika and by memo number 193 dated 22/9/2017, the selection of the petitioner was set aside and she was directed to hand over the charge of Anganwadi center to the Sahayika. He submits that a writ petition was filed before this court being WPS number 7416 of 2017 by the order dated 2/7/2019. Holding that the order itself was wholly without jurisdiction, and was not sustainable in the eyes of law. He submits that a direction was issued by this court to reinstate the petitioner from the date of passing of the order restraining the petitioner from discharging her duties. However, liberty was reserved with the respondents to initiate a fresh proceeding against the petitioner after following due procedure of law and after giving ample opportunity of hearing to the petitioner. The learned counsel submits that thereafter, order contained in memo number 461 dated 14/10/2019 was issued, enabling the petitioner to join her duty immediately pursuant to order passed in the writ by the writ court, but the petitioner has not been paid the salary for the intervening period. She remained out of employment, that is from 22/9/2017 to 13/10/2019, and consequently the present writ petition has been filed. The learned counsel has submitted that he is not aware, nothing has been placed on record as to whether a fresh proceeding was initiated against the writ petitioner pursuant to order passed in WPS number 7416 of 2017. And the present writ petition is confined to the salary of the honorarium of the petitioner during the intervening period. The learned counsel for the respondents has submitted that though in spite of order passed by though no counter affidavit has been filed in the present case, but there was no direction issued by the writ court to pay salary for the intervening period, and the writ court's order has been complied in letter and spirit by allowing the petitioner to join the post pursuant to the order passed by the writ court. The fact remains that during the intervening period, the petitioner had not performed any duty. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and after considering the facts and circumstances of this case, this court finds that the earlier order of the earlier order contained in memo number 193 dated 22/9/2017 was set aside by this court and the petitioner was directed to hand over the charge to Anganwadi Sevika by the said memo. Sahika by the said memo, and the findings of the learned writ court are as under page 20 में last 3-4 paragraphs quote कर लीजिएगा. This court finds that though the order dated 22/9/2017 was set aside, but no consequential relief was granted to the petitioner regarding payment of honorarium for the intervening period from 22/9/2017 to 13/10/2019. It is also not clear as to whether any fresh proceeding was initiated against the petitioner or not pursuant to order dated 2/7/2019. The fact remains that during this period, the petitioner did not perform any duty. Since there was no direction, in view of the aforesaid facts and circumstances, this court is not inclined to direct the respondents to pay honorarium to the petitioner for the intervening period from 22/9/2017 to 13/10/2019. Accordingly, this writ petition is dismissed.
Item 7, WPS 57 of 2023.
This petition.
One IA is pending for amendment of para 1 and prayer.
What prayer are you seeking amendment?
Evidently, date has been wrongly mentioned in prayer.
There is no IA, I don't find any IA.
IA number 2481.
What is the main relief?
Mainly regarding the due salary from May 22 to December 22. Second amendment regarding the one para second Roman 2. Nature of amendment directed the respondent to regularize his service with effect from 14/6/2022. It should be 2020 also. And later on, the departmental name is wrongly mentioned in this prayer. Para number 4 of the IA need to be amended.
Para number 4, you just want to substitute this relief completely.
No.
What changes? You just tell us which line, which para number. Right. You just read para number 4. By adding as under, you want these paragraphs to be added.
No, sir. Seeking permission to withdraw this IA.
Yeah, you just tell us why did you file this IA?
For date is wrongly mentioned.
Which date is wrongly mentioned? Which
So-
para, which page number?
Prayer 2, Roman 2, capital 2. 14/6/2022. It should be 14/6/2020.
Okay. What else?
And second, Lordship, departmental name, Department of Personal Administration reform may be deleted also.
Which is the department?
Department DC Palamu, Lordship. Respondent number.
DC Palamu is a party?
Yes, respondent number 3. Only I click for deleted Lordship.
लिखिए IA number 2481 of 2023. The counsel for the petitioner submits that certain error has been crept in para number 1 within bracket Roman 2 of the writ petition. The date mentioned in the fourth line of page number 4, para number 1 within bracket Roman 2 would be 14/6/2020 instead of 14/6/2022. He has also submitted that in the same paragraph, the name of Department of Personal Administrative Reforms and Rajbhasha, Government of Jharkhand be deleted and instead respondent number 3 be mentioned.
There is no
Deputy Commissioner Palamu,
not mentioned in my eye, only delete Lordship.
डिलीट हो जाएगा?
Yes.
रिस्पॉन्ड नंबर 3 डालना है?
इसमें आइए में नहीं है Lordship.
डालना है?
डाल देंगे Lordship.
And the respondent number 3 be mentioned is to be inserted. The learned counsel submits that although no specific prayer with regard to insertion of respondent number 3 has been made in the interlocutory application, but it is the respondent number 3 who is the competent authority to take a call in the matter. Right? Any objection?
No.
The learned counsel for the respondents has no serious objection to the prayer made. Considering the aforesaid submissions, the learned counsel, the IA number so and so is hereby allowed to the extent, to the following extent. A, the date mentioned in page 4, para 1 within bracket Roman 2 be now corrected to 14/6/2020 instead of 14/6/2022. B, the Department of Personal Administrative Reforms and Rajbhasha, Government of Jharkhand be deleted and deleted in the same paragraph and respondent number 3 be inserted. Khali respondent number 3 लिख दीजिए. Let the aforesaid amendments be carried out during the course of the day. कर देंगे अभी?
Amendment file कर देंगे. Amended. Within a week.
फाइल करने की कोई ज़रूरत नहीं है. You just do it. लाल कलम इनको दीजिए सुनने. संजीत जी, इनको ज़रा मदद करिए करेक्शन करने में. राइट? बताइए मेन केस क्या है?
The prayer one is already fulfilled, Lordship. There is no grievances regarding the prayer one.
Okay. You are seeking regularization.
Regularization.
Since when are you working?
14/6/2020.
14/6/2020 से काम कर रहे
नहीं,
हैं?
14/6/2010.
कब से काम कर रहे हैं आप?
14/6 since 2010, 14/6/2010.
Where is your appointment letter? Is there any? Or no appointment letter was issued?
Page number 19, Lordship. And recommendation letter is page number 20. In page number 20 is the recommendation that has been recommended by the block development officer Hydernagar to Jila Sachiv Jila Parishad.
Then what happened? They have not taken any decision.
No, Lordship, they have not taken, even he has not
Are you
received
still working? Are you working or not working?
Now I am working, Lordship, but after filing of the writ, he restrained to doing the work and not payment the salary, Lordship. Therefore, I pray in third para to issuance so cause to respondent number 5 why he restrained the petitioner for doing the work and stop the salary without any valid reason. But Lordship, now she is working. He the respondent issue the experience certificate, Lordship, but that is not on record. He just sent me today.
Counter affidavit has been filed.
We have filed a counter affidavit.
What is his
We have stated with regard to that his appointment was irregular. The block development officer who has appointed her was not authorized to appoint her as per the letter of 2015, Your Worship. He was only authorized to appoint only 4 persons on a daily wages. She was appointed on a daily wages, and the work was not taken from her regularly, Your Worship. Although the salary was not paid for certain period, the fund was not available. Now the fund has been released as per his instruction, because as per our instruction, the fund was not.
You were entitled to appoint her on daily wages?
That officer was not entitled to appoint her on daily wages because he was only.
Who was entitled to appoint her on daily wages?
Block development officer was the drawing and disbursing authority of that
He could
area.
have appointed.
He had appointed him, but he was only allowed to appoint only 4 persons. 2 persons was computer operator, 1 was night watchman, and 1 was driver. And she was a sweeper, and she was being appointed by the block level of block development
You don't
officer.
need a regular sweeper?
There is no instruction with regard to the only 4%. The funds was made available through Narega scheme. That scheme, under that scheme, only 4% fund for 4 persons were available. Since no fund was there for her, that's why she was not being paid the honorarium. But he has taken the work.
Under Narega, there is no provision for appointment of a sweeper?
No fund was that authorized for that amount, for taking work as a sweeper. So our only instruction, but as per his submission that she is working now, as per our instructions, he was stopped from working in the year 2022 itself.
And you have even stopped payment?
Now she has received. We have even mentioned that the work which she has performed, she'll get the remuneration for the same. That time there was no funds, that's why she didn't receive that amount. But now, as per his submission, she has received all that amount. With regard to the current status, whether she has been re-employed again and she's working continuously, so we have to seek instruction with that.
Where is a circular by which he was entitled to appoint 4 persons?
You're not sure. That is annexure B of the counter affidavit. That's page 90, annexure B. A computer of I may be allowed to read this.
उक्त आवंटित राशि
Yes, sir. उक्त आवंटित राशि से बाहरी स्रोत पर निम्न कर्मियों की सेवा ली जाएगी। कंप्यूटर सहायक ऑपरेटर क्षेत्रीय स्तर पर प्रत्येक 7 ग्राम पंचायत पर 1 कंप्यूटर सहायक एवं जिन प्रखंड में 7 से गुणक के पश्चात 3 अतिरिक्त ग्राम पंचायत हैं, वहां 1 अतिरिक्त पद के आधार पर 4350 पंचायतों के लिए संलग्न अनुसूची 1 के अनुसार कुल 659 कंप्यूटर सहायक की सेवा बाह्य स्रोत से लिया जाएगा। जिला स्तर पर 2 MTS चालक, अनुसेवक, सफाई कर्मी, झाड़ू केयर टेकर, जनरेटर ऑपरेटर, रात्रि प्रहरी, आशु लिपिक, सह टंकक आदि कुल 48 एवं प्रखंड स्तर पर प्रति प्रखंड में 2 MTS स्टाफ कुल 558. So she was appointed at a block level प्रखंड स्तर. 2 MTS मल्टीटास्किंग स्टाफ कुल 528. इस प्रकार कुल 576 MTS की सेवा बाहरी स्रोत से ली जाएगी यथा अनुसूची 2।
कहाँ लिखा है कि इसमें सफाई कर्मचारी को नहीं लिया जाएगा?
Your Lordship, बाहरी स्रोत से 2 and multitasking staff including driver for
Multitasking
जिला
staff,
Your Lordship,
only multitasking staff.
Multitasking
ठीक
staff.
है? Multitasking staff में कौन कौन है? ड्राइवर, अनुसेवक, सफाई कर्मचारी, झाड़ूकश, केयरटेकर, जनरेटर ऑपरेटर, रात्रि प्रहरी, राइट?
जिला स्तर पर Your Lordship, in that
नहीं
जिला स्तर
एवं
पर
प्रखंड स्तर पर प्रति प्रखंड पर 2 MTS मल्टीटास्किंग स्टाफ। तो मल्टीटास्किंग स्टाफ तो ऊपर दिया हुआ है ना, who will constitute multitasking staff, right? Now you tell us that you had appointed 2 operators, computer operators.
operator, one is driver
Okay, one is driver,
and one is night watchman.
second is
That will
night
include a
watchman.
MTS Your Lordship. In MTS night
Okay.
watchman, that will include
But दो MTS
two
में
is allowed.
तो
And two computer
दूसरा
operator.
किसको लिए?
Your
सेकंड
Lordship, one in that
एक तो
includes
ड्राइवर हो गया।
that includes driver Your Lordship.
अच्छा, that includes
MTS
driver.
includes driver
Okay.
and
कब अपॉइंटमेंट किए?
that is not there.
और ये
कब-
इनिशियली कब एंगेज किए? अगर उनका अपॉइंटमेंट इनके बाद हुआ है,
Your Lordship,
then they cannot be engaged.
Your Lordship. That we'll have to seek instruction when they have been appointed and since when, as per which scheme she has been appointed, and that we have to specific instruction with that regard. Your Lordship.
Right? इनको हटा के आप ड्राइवर तो नहीं रख सकते ना?
This letter has come in the year 2015. And she is claiming to be appointed in the year 2010. So we need to seek instruction. And she is now claiming that she is again working now. So we'll have to seek instruction with that regard. We'll file a fresh affidavit.
और वो जो ड्राइवर जिसको अपॉइंट किया था वो कंटिन्यू कर रहे हैं?
That is the counter
is
is
also
silent.
missing.
That is the counter is entirely silent on that part.
The learned counsel for the parties have advanced their arguments. The learned counsel for the respondents, while referring to the counter affidavit, has referred to page number 19 annexure B to submit that at the stage of block level, only 2 multitasking staff could have been employed. Multitasking staff included driver, peon, सफाई कर्मचारी, झाड़ूकश, केयरटेकर, जनरेटर ऑपरेटर, नाइट गार्ड and typist. The learned counsel has submitted that 1 driver and 1 night watchman have been inducted pursuant to the said circular dated 15/7/2022, but it is not clear as to when they were inducted. The case of the petitioner is that she has been working since 14/6/2010, and except for the intervening period, except for a short intervening period, she continued to work, and as per the instructions received by the petitioner, she is continuing to work as on date. The learned counsel for the respondents is directed to seek instructions and file a supplementary counter affidavit giving the details of the driver and the night watchman along, and bring on record their appointment letter, and also inform this court as to whether the petitioner can be adjusted under the aforesaid circular, being otherwise qualified, having been working with the respondents as a sweeper. How much time do you need? Take a sympathetic view. 10, 12, 15 साल से किसी से काम करा के you just can't do this.
3 weeks.
Rather, you should have adjusted her first.
She should have. She's
The
working
fact
in the
remains that the petitioner, having been working for quite some time, this court is of the view that the petitioner, having been working since a long time, ought to have been adjusted उतना छोड़ दीजिए उसको, आप कराइए इसको, ठीक है? How much time do
3
you
weeks.
need? You take instructions from whom will you take?
From the Deputy Commissioner.
Deputy. The affidavit should be filed by the Deputy Commissioner or by a person duly authorized by him.
Admitted salary may be paid or said.
Sorry?
See, the
Current
respondent
salary.
has not paid any
Current salary.
current salary.
With regard to that, we have
If-
stated,
if-
but earlier he submitted
Right,
that.
if there are any dues of the petitioner for the work she has done or for the work she is doing, the same be immediately released in favor of the petitioner. Pose this case on 4th of March. The supplementary counter affidavit should be filed by 29th February. नहीं पेंडिंग है. Sorry? हाँ वो आप कर दीजिए, आइए मैं करेक्शन कर दीजिए. उनको थोड़ा वहाँ साइड में ना जाके इनको बताइए कहाँ करेक्शन.
Item 8, WPS 71 of 2023.
Yes, petitioner.
Raised for quashing of advertisement 1. This is annexure 21, page number 21. With regard to the rule number 7,
The selection process is over. So what purpose will be served?
because at the judgment of Ramesh Hansda case, the condition which has been mentioned in the advertisement, which is ultra virus.
Lordship, the judgment has been passed on 16/12/22, and the contractual appointment of the community of health officers was prior to that order only. It was passed on 31/5/22.
And successful candidates are also not here. किसका wash कर देंगे हम?
मेरा प्रेयर है कि क्वेश्चन करना है सब पूरा नोटिफिकेशन एंड इफ दे अपॉइंटेड एनी पर्सन on this basis which has been also questioned also.
The contractual.
The judgment was passed when?
Judgment was passed on 16/12/22, and prior to that it was the committee
That
had
recruitment process was
हाँ
completed.
31/5/22 में ही हो गया था.
My specific question has been replied by para 8 of the counter affidavit, but which has been only mentioned. It is also pretend to mention that since the process of contextual appointment started before the judgment of Honorable High Court of Jharkhand on 16/12/2012 and hence it was on going on process, the entire process was accomplished after procuring the legal advice of the learned advocate general, which has not mentioned that the process has been completed. On what basis he has stated?
Where is the judgment of Ramesh Hansda? What was the judgment?
Judgment, Lordship, let's see. I refer the para. I have relevant flag has been
In para
inserted.
7 only they have mentioned the contractual recruitment of community health officers has been published and
Page
the contractual
page
appointment.
14 में kindly see Lordship first, जो relevant है judgment का. परंतु यह झारखंड राज्य के आरक्षित नीति से आच्छादित अभ्यर्थियों के मामले में झारखंड राज्य के
अवस्थित मान्यता प्राप्त शैक्षणिक संस्थान से मैट्रिक 10वीं कक्षा एवं इंटरमीडिएट 10+2 कक्षा उत्तीर्ण होना संबंधित प्रावधान शिथिल रहेगा।
So what is it?
तो यहीं पर था कि अनिवार्य रहेगा, इससे पहले मान्यता प्राप्त शैक्षणिक संस्थान से उत्तीर्ण होना अनिवार्य होगा और अभ्यर्थियों को स्थानीय रीति रिवाज एवं भाषा एवं परिवेश का ज्ञान होना अनिवार्य होगा। और यहाँ एडवर्टीजमेंट में भी यही बात, जो क्लॉज नंबर 7 है इनका एडवर्टीजमेंट का, in which specifically mentioned that
Have been made that candidates will have to pass 1 out of 12 regional or tribal languages, Your Ladyship. Under Rule 1 of the Set Rules of 2021 provisions in Para 8 of the counter affidavit we have already mentioned. Will have to pass matriculation 10 and intermediate, that is 10+2 from the Education Institute of Jharkhand.
The recruitment was under this rule?
Contractual
No.
basis, Your
Where is
Ladyship.
under which rules the recruitment was made? Under which rules the recruitment was made?
झारखंड गजट नंबर 565 dated 18/11/2022, which has been squashed and set aside by the page 21, Lordship. Let's see, may kindly see the rule, advertisement का rule 7.
Page 21.
So last में मैट्रिक 10+2 and knowledge of local language will to applicable as per झारखंड गजट नंबर 565 dated 18/11/2022.
Okay. And this has been set aside?
This has been
By
ultra
which
vires.
paragraph? Which paragraph it has been set aside?
Para 59.
Para 59. It is Rule 2 and 7 of Rule 2021 has been set aside.
But we have mentioned Para 7, Your Ladyship, contractual appointment 167 candidates have been made on the
That's
basis.
agency then. Yes.
Yes.
2021 has been set aside. 2022 has not been set aside.
This is the rule, but notification number has been mentioned here. This advertisement is not a rule mentioned. This is the gazette number has been mentioned.
Where is that gazette number? From where will I get that gazette number?
So rule is the 2021, but the gazette number
Where
has
is
been
that gazette? From where do I get that this rule was published in this gazette?
I have not annexed.
Your Ladyship, those papers are not annexed in the writ any.
Who are you? You are a candidate
Candidate.
and you are disqualified under this advertisement.
Not eligible due to this the clause number 7.
What is your qualification?
Minimum qualification, I have stated that the Bachelor of Homeopathy, Medicine and Surgery. I have stated in para 5 of my petition.
What is it that you do not have? You are already 10+2. You don't have knowledge of local language.
No, because
What is it that you are not qualifying?
10 matric and 10+2 have not passed in the Jharkhand. Due to this reason, the petitioner was not able to.
It does not say that the matric and 10+2 should be from Jharkhand.
Yes,
From where? From where do you say this?
Para 7, matric, comma 10+2 and local knowledge of local language will be applicable as per Jharkhand Gazette number. And as a gazette number has been referred in the rules 2021, and wherein it has been mentioned that the matric and 10+2 is required to pass in Jharkhand, state of Jharkhand.
The state of Jharkhand only.
Yes.
लिखिए. The learned counsel for the parties are present. This writ petition has been filed on 4/1/2023 for the following relief. The learned counsel for the petitioner has submitted that Rule 2 and Rule 7 of Jharkhand Staff Selection Commission Examination within bracket graduate level bracket close conduct then bracket amendment bracket close Rule 2021 has been declared to be ultra vires by judgment passed by this court on 16/12/2022 passed in WPC number 3894 of 2021 and other analogous cases. The learned counsel submits that as per the writ petition, upon passing of the aforesaid judgment, the advertisement ought to have been withdrawn by the respondents. And therefore, the present writ petition has been filed immediately after the pronouncement of the aforesaid judgment. The learned counsel appearing on behalf of the respondents has submitted that the advertisement involved in the present case was not the subject matter of consideration in WPC number
Because this
3894.
post is of only for 1 year, Your Ladyship. It isn't already mentioned.
In WPC number 3894 of 2021, she has also submitted that as per the advertisement, the post was only for contractual appointment of 1 year only. The learned counsel has further submitted that as per the counter affidavit, the recruitment process is over and the successful candidates are not even party in the present proceedings. She submits that the recruitment process was over much before filing of the present writ petition, and therefore no relief be granted to the petitioner. The learned counsel has submitted that merely because the Gazette, Jharkhand Gazette number, that should be sufficient. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that the recruitment process involved in the present case was not subject matter of consideration in the writ petition being WPC number 3894 of 2021 and other analogous cases, though the Rule 2 and 7 of Jharkhand Staff Selection Commission Examination within bracket graduate level bracket close conduct within bracket amendment bracket close rules 2021 ये graduate level
ग्रेजुएट लेवल
ये तो graduate level का है ही नहीं
में प्राथमिक ग्रेजुएट लेवल का ही एग्जाम
नहीं तो ये जो एडवर्टीजमेंट आप दिए हैं इसमें ग्रेजुएट लेवल कहाँ है?
ये ग्रेजुएट लेवल का नहीं है, 10+2
ग्रेजुएट लेवल 10+2 है ना?
हाँ 10+2
10+2 है।
ये तो ग्रेजुएट लेवल का नहीं है. And in the present case, the qualification required was metric, 10+2 and knowledge of local language as applicable as per Jharkhand Gazette number 565 dated 18/11/2022. The said Gazette notification has not even been annexed in the repetition nor the.
Let's make I see this.
Yeah.
This department will also withdraw the advertisement on the basis of this judgment.
As we do not.
If plots, let us see.
विड्रॉ दूसरा डिपार्टमेंट क्या विड्रॉ
यही
कैसे
department
आप हमको बताइए ग्रेजुएट लेवल एग्जाम है ये
नहीं इंटर लेवल even that the inter level examination
they
the
might have
advertisement
we are
has
not
been
concerned
withdrawn.
with that we are not concerned with that they might have nor the state notification has been produced before this court for consideration. The fact remains that as per the counter affidavit the recruitment process is over and it was only for a period of contractual period of 1 year.
1 year.
The successful candidates are not even party in the present.
Can be extended as per need, performance, and approval of competent authority.
Subject to approval as per need, performance, and approval of the competent authority. In view of the aforesaid facts and circumstances, this court is not inclined to entertain this writ petition, which is hereby dismissed. Grant the relief as prayed for by the writ petitioner in this petition, which is hereby dismissed. So this one I रखिएगा इसको हटाइएगा मत इस statement. Till next case.
Item 9, WPS 76 of 2023.
Yes, petitioner.
Petition was for the introduction of the petitioner in the service record as a woman. She is
As
the
a?
wife of the employee, BCCL, my lord. Her name was not in the service record as well as in the nominee anywhere. And as such, she has come to know that for the service benefits and other, it should be required for the nomination. Accordingly, she has applied for the nominee.
The husband is alive?
Husband has been retired. During the pendency of his service, my lord, it was filed. Thereafter, my lord, he has retired and now.
He has given the name of some other lady as wife.
Initially, some other lady was there and she has died as per the counter.
When did she die? After his retirement or before his
Before
retirement?
his retirement. It is from their counter.
When did you get married?
In the year 87. In the year 82.
And when did she die?
As for counter, my lord, it is, I don't know, but there is a counter on the basis of counter.
What is your name?
I am Kalyani Devi.
And the earlier wife was Chanchala Devi.
Chanchala Devi.
She died.
She died.
Did she die?
In 2004, the employee submitted the death certificate that we have annexed in issue B series, and he never declared.
2004, she died. But he never declared the present petitioner as his wife. You have a marriage certificate?
No, I am married. So for the wife is concerned, she is getting the 125 maintenance claim as a wife.
That is only a preliminary summary proceeding. That will not conclude that
Because
you are the
on
wife.
that point's declaration is the wife, and accordingly, as a wife matter she was getting.
You go and get yourself declared as wife through proper suit. That is not binding on them. That is just a summary proceeding, just prima facie. Even two persons are living together, they are entitled to maintenance. Your husband should go and you are seeking maintenance also, very.
Yes, yes. On that grounds, my lord, she is claiming that he.
Moreover, my lord, the employee has already superannuated. Entire retirement benefits he
Has
must
already
have
been
received.
paid.
And now,
That
what
is-
Family pension is also there.
family pension is there after the death of the employee. That is very meager amount. for that in
gratuity,
future.
other lack
When
of
your
revenue.
husband is not there with you,
Employer
he must have disputed the relationship of husband and wife.
But it has not been disputed. He has accepted that he is the wife and accordingly maintenance was there, my lord.
Where is that acceptance and where is that order of maintenance?
That is Annexure 1 2.
My lord, one thing. In 82, she claims to be
Exactly.
got married to the employee,
82.
ex-employee. 82. 87, he entered into the service. He retired in the year 23. In 23, she has filed this writ before this honorable court that her name should be included. Lifelong, her name was.
And the first wife died in the year
in
2004.
2004 itself.
So,
Even after
your marriage was during the lifetime of the first wife.
No, I am the first.
She is the first.
Otherwise, he will be.
maintenance, so inko, that is there, my lord. Admittedly, he says that he is getting the maintenance.
Where is that maintenance order?
That is
Para
Annexure 2,
9
my lord. Page 13, my lord.
Para 8 and 9 of his writ petition.
No, give.
And
I want to
annexure
see
two
the
is
maintenance order.
That is Annexure 2.
Annexure 2 is 127 order.
That is the enhancement of the initial.
Where is the initial order?
Initial.
Where is the initial order?
Initial order, I could not find on it. But on the basis of the initial, he was initially getting 500. Thereafter, it has enhanced 5,000.
अभी भी मिलोज 127 would lie the appropriate remedy जहाँ ये आगे भी enhancement या जो भी claim कर सकते हैं even from the retirement benefits that he has got.
Your name is Gambhir Thakur. Your husband's name is Gambhir Thakur.
Hari Thakur here.
Hari Thakur.
Thakur. In the suit, you disclose the name of your husband as Gambhir Thakur.
Alias Gambhir Thakur.
Alias.
Alias Gambhir Thakur. But he is Hari Thakur. In the service record and everywhere.
The payment was being deducted from the salary and was being paid to him.
My lord, no specific statement has been given by us in that respect.
Please give.
I'll find out whether it was being deducted.
Learned counsel for the parties are present. The learned counsel for the petitioner has submitted that though the husband of the petitioner had disclosed the name of his wife as Chanchala Devi in the service records, but the petitioner is the legally married first wife of the employee who retired as back as on
34/20/23.
34/2023. He submits that a counter affidavit has been filed enclosing the death certificate of Chanchala Devi, who died in the year 2004. The Learned Counsel submits that the petitioner is taking maintenance from the ex-employee of the respondent by virtue of maintenance case number 1 of 1993 dated 5/8/1997 and maintenance alteration case number 40 of 2017 dated 5th of April 2019. The Learned Counsel has submitted that the order of maintenance alteration case number 40 of 2017 has been annexed as Annexure 2 to the petition, and as per the order, a direction was issued to the employer for deduction of salary from the employee to ensure payment to the present petitioner in her saving bank account. The Learned Counsel submits that now it is not open for the respondent to contend that the petitioner is not the legally wedded wife of the employee who has retired. The Learned Counsel has also submitted that consequently the petitioner would be entitled for certain service benefits if the husband of the petitioner expires before her, and in order to secure her rights, she had filed application before the respondents for inclusion of her name in the service records. यही है कहानी?
मतलब लेकिन रिप्रेजेंटेशन में हालांकि जो फैक्ट ये रखे हैं उसमें बोलते हैं कि मेंटेनेंस ऑल्टरेशन केस 18/2022 भी दर्ज करवाइए जो फिलहाल लंबित है। ये 2022 का
ये तो ऑर्डर ही लगा दिया।
ऑर्डर लगा है और रिप्रेजेंटेशन जो हमें दिए हैं 2022।
That is why we have to go through. You see, counsel also does not go through the orders. But client का तो बात ही छोड़ दीजिए. He has also not seen this. That there is an order for deduction from the salary, right? Learned Counsel for the respondents. You have filed your counter.
I have filed my
Praised for 1 week time should be sufficient.
2 weeks.
2 weeks time to file a supplementary counter affidavit in this case to bring on record if the order passed in maintenance alteration case number 40 of 2017 was duly complied by the employer or not. Right? The supplementary counter affidavit be filed by 19th of February, post this case on 21st of February. If you have done it, you have to include her name.
वैसे मतलब इसमें प्राइवेट पार्टी को भी जाना चाहिए।
प्राइवेट पार्टी कौन है?
इसका हस्बैंड जो एम्प्लॉय है, he has not appeared even that he is an important person।
वो कभी मानेगा?
But he at least पता नहीं नोटिस गया है कि नहीं। Anything if any direction is
इसीलिए तो उसका नाम ही कटा कि वो मेंटेनेंस ले रहे थे बोल रहे। तो ऐसे ही भागेंगे।
Issue notice to the respondent.
He has been made respondent.
Okay. Issue notice to the respondent number 5. Let the notice be respondent number
4.
कहाँ का है?
करके धनबाद कुटकी पोस्ट ऑफिस
Kari
कुटकी
town.
डिस्ट्रिक्ट।
Resident of Kari town, POPS Kutki district.
Okay. Issue notice to the respondent number 4. Let the notice be served upon respondent number 4 through the concerned police station, officer in charge of the concerned police station. यहीं से चला जाएगा?
हाँ मतलब
स्टेट को पार्टी करने का जरूरत नहीं।
नहीं इनको रिक्विजिट फाइल करनी है।
हाँ, and the requisites be filed by day after tomorrow.
Item 10, WPS 97 of 2023.
In this case, we need to file a rejoinder as counter has been filed at British Agriculture University.
Counsel for the parties are present. Counsel for the petitioner, how much time?
3 weeks.
3 weeks for rejoinder. Admit कर लेते हैं 30 साल बाद take up होगा. What is this? For rejoinder you need 3 weeks time. Is there any problem in filing rejoinder? 13/9/23 the counter affidavit was filed. थोड़ा सा client का ख्याल करिए. They are banking on you. As prayed for, pose this case on 21st of February 24. The rejoinder to the counter affidavit be filed latest by 19th of February.
Similar situated cases, serial number 10, 11 and 12.
11 and
12, next two matters are same.
11 and 12 में भी
And 19 as well.
11, 12, 19 सब कर. They are all identical matters.
Yes, sir.
Common order बनाइएगा. The counsel for the parties jointly submit that similar issues are involved in the present cases. Let all these cases be tagged. Okay, next.
Item 30, WPS 151 of 2023.
In all the cases counter filed. In all the cases counter filed.
Serial number 19 only state has filed, British Agriculture University is not filed. That will be filed in the, during this period only.
Till next. What is this? This one?
Item 13.
Yes, who is for the petitioner? Succession certificate has been obtained.
I'm appearing on behalf of respondent number 7.
7, who is 7?
7 is the wife, Lordship.
What is your objection?
Objection that I am claiming I am the first wife. I am claiming to be the first wife, Lordship. पर इसमें जो है पहले भी हम लोग एक रेट फाइल किए थे जिसमें ऑर्डर हुआ था बाय दिस ऑनरेबल कोर्ट कि आप सक्सेशन इसमें फाइल करिए और ये लोग भी सिमिलर रेट फाइल किए थे जिसमें इन लोग को भी ऑर्डर हुआ था सक्सेशन फाइल करने
क्या हुआ?
तो उसमें तो अभी तक हम लोग को ऑर्डर था इसमें कि काउंटर फाइल करेंगे इस रेट में योर
आपको सक्सेशन मिल गया?
नहीं योर
नहीं मिला ना? पिटिशनर को मिल गया?
नहीं
पिटिशनर को भी सक्सेशन नहीं मिला?
अभी तक नहीं फाइल किया.
Annexure 4, why have they filed the writ petition again? Where is the petitioner? You are there?
Yes.
Oh, yes. You have received succession?
No.
There was a writ petition earlier, Sanjukta Devi.
Yes, sir. This is the third round of litigation. We have mentioned as part 2, my lord.
What is the fresh cause of action?
Now the son is before your lordship. Earlier the mother was before your lordship. Mother was, it was said that he has a second wife, and therefore now the son is before your lordship.
Through which wife?
Second wife.
Through second wife.
The first wife has a daughter who is aged about 45 years. So she is
not eligible.
Not eligible. And the only.
What is the date of death?
Date of death is 2021. This is 9th of May 2020. Para one itself I mentioned.
Yes, what is your stand?
Our stand is that child from the second wife, your lordship, is not entitled. I am relying upon a decision of division bench, your lordship.
Child from the second sound
Not
child?
entitled.
Not entitled.
Not entitled.
He is not. He has got no rights.
As far as pension is concerned, as far as
Kolkata.
Kolkata, yes. Division bench, your lordship.
No, maybe division bench.
Your lordship, may kindly-
Show us to us. We will decide it.
Yes, yes, your lordship. Only
You tell us that is there any legal impediment in giving employment to a child of second wife,
Yes.
Particularly when there is no other person through the first wife to claim.
The first wife has also claimed compassionate appointment, Your Lordship. If she has, if she is not entitled for compassionate appointment, then monthly monetary compensation is to be paid to the wife, Your Lordship, to the first wife, Your Lordship. And as far as this decision, Your Lordship, may kindly see.
This has been tested before Supreme Court.
Your Lordship, or relying upon decision of Supreme Court, this has been passed.
This has been tested before Supreme Court or not tested?
This particular judgment has not been tested, Your Lordship, but relying upon decision of the Supreme Court, this decision has been rendered.
Now there is a recent judgment of Supreme Court regarding illegitimate children.
With respect to, Your Lordship,
illegitimate children, second wife?
Yes, Your Lordship, but that is with respect to the property, Your Lordship. That is, it has been held, Your Lordship, that the compassionate appointment is not a property of her. It is being granted as per the scheme. As far as pension is
Therefore,
concerned,
I want to know, is there any legal impediment in the scheme that an illegitimate child will not be?
This has been decided with respect to Eastern Coalfield Limited case, Your Lordship. The 5th page, Your Lordship, this has not been numbered, Your Lordship, but from 5th page itself, Your Lordship. Section 16(1) of the Hindu Marriage Act, 1955, Your Lordship. I am reading last 2 lines of page 5, Your Lordship. That has not been numbered, Your Lordship. Section 16(1) of the aforesaid Acts cleared a legal fiction where a child born out of void marriage shall be held to be legitimate. Section 16(3) of the said Act restricts such legal presumptions to the right of such child only to the property of his parents and none else. It is therefore clear that Section 16 of the Hindu Marriage Act 1955 presumes a child born out of void marriage as a legitimate only for the purpose of entitling him to claim rights in or to the property of his parent, but not any other things. It is settled law that the public post is not a heritable property. In State Bank of India versus Jaspal Kaur reported in 2007, Volume 9 SEC 571, the Apex Court held that it is clear that the public post is not heritable. Therefore, the right to compassionate appointment is not a heritable property. In fact, it is an exception to the rule of regular appointment by open competition. Such exceptions to the rule of regular appointment is therefore a privilege extended by the employer in terms of
right to compassionate appointment is not a heritable property.
Yes,
it only means that if a person has died and there is a son and he dies, then he will then it will not his son will not inherit the right to have a compassionate appointment.
Yes.
Right? But here is a case who is the son himself. How do you make a distinction between a legitimate son and an illegitimate son?
Your Lordship, in this case, the first wife has also claimed
Counterfile कर दी?
counterfile कर दी है.
ठीक है, इसको डिसाइड करते हैं, ठीक है? और ऐसे नहीं खाली एक जजमेंट से डिसाइड नहीं करेंगे, जितना जजमेंट रेफर्ड है सब लेकर आएंगे. और लेटेस्ट जो जजमेंट सुप्रीम कोर्ट का है रिगार्डिंग द राइट्स ऑफ इलिजिटिमेट चिल्ड्रन, आई होप यू आर अवेयर ऑफ दैट. इफ नॉट अवेयर, मेक योरसेल्फ अवेयर. राइट, देयर इज अ recent judgment. You just come with that also. And it is not in dispute that the daughter of the first wife is not legible, not eligible.
I have stated in the writ application they are not denied in the court.
And she has not lodged any claim.
No.
Has anybody else lodged any claim before?
The first wife has lodged a claim with respect to the appointment, Your Lordship.
Appointment of her appointment or
of
somebody
her
else?
appointment. Of her appointment.
What happened to that claim?
But since
that writ application has been withdrawn.
That Your Lordship directed to obtain a succession certificate. That is an
Because
extra 4.
both of them were fighting.
Both of them were fighting. Therefore, an extra.
Ultimately, the succession certificate has not been obtained.
That has not been obtained. That is an extra 4 and 5.
4 and 5.
But as far as son is concerned, this is.
What is the age of the first wife? Is in the writ petition itself, it has been mentioned 56 years. She is not eligible for compassionate appointment by any means.
Then she will be allowed, Your Lordship, the monthly monetary compensation. Since there is an order of this honourable court, to bring a succession
She has
certificate,
not
therefore
come for monetary benefit.
such
Now the management is putting the words in the mouth of the private respondent.
Who is for the private respondent? You are for the
For
private
number
respondent. Have you filed any counter affidavit? You filed your counter. WPS number 151 of 2023. The issue involved in the present case is whether an illegitimate son through second wife would be entitled for compassionate appointment. The learned counsel for the petitioner submits that neither the first wife nor her daughter is entitled for compassionate appointment as they have already crossed the age bar. The learned counsel for the respondents has relied upon a judgment passed by the Honorable Kolkata High Court decided on 7/3/2013.
in between Eastern Coalfield
अरे
Limited and
कितना बोलते हैं भाई?
जी.
Why? The judgment is there with us. Can't I see this?
Yes.
It passed in the case of Eastern Coalfields Limited versus Dilip Singh and others to submit that it has been held that illegitimate son does not have a right for compassionate appointment. Compassionate appointment is not a heritable right. The learned counsel has also submitted that if the compassionate appointment is granted to the petitioner, the first wife would be deprived of the monetary compensation, as monetary compensation is payable in lieu of compassionate appointment. Counsel for the respondent number 7 is directed to seek instructions and file a counter affidavit in the present case. Let the counter affidavit be filed by 19th of February. Post this case on 21st. In the meantime, the petitioner may also file a rejoinder to the counter affidavit filed by the respondent BCCL.
That I already.
Eastern.
That rejoinder is already.
That is already done. अच्छा आने दीजिए rejoinder को फिर करते हैं.
What is it the revenue matter?
Let me just see. दिखाइए. We have done till 10, I think. कहाँ तक किया हमने?
30.
8:13.
Just which all, this is 13, right? Which all are the cases where no counter affidavit has been filed in spite of order of this court?
Next case I have filed with this.
You have filed your counter? We'll just quickly take up that. 14 call करिए.
Item 14, WS 157 of
I
2023.
filed counter for the JPC members. The rational prayer was rejected by the other court against the others, including my.
There are other 3 prayers also there, Lord, so I have to file the rejoinder to the counter affidavit. 1 week time may be given, Lord.
Just yes. देखिए
State is also
WP
filed.
just a moment.
State is also filed.
WPS number 157 of 2023. Counsel for the parties are present. Counsel for the petitioner raised for time 1 week time to file a rejoinder to the counter affidavit. Let the matter be posted on 13th of February 24. The rejoinder be filed latest by 12th of February. Next. Call करिए आप.
Item 15 wrong.
अच्छा wrong. Next.
Item 15, WPS 186 of 2023.
Yes. Counter file.
We are filing it today.
Okay. WPS number 186 of
It can
2023.
be decided.
Sorry?
Because it can be decided since the para 26 says that it deals with our prayer, wherein they say that they agree with our prayer.
Just a moment. WPS number 186 of 2023. Counsel for the parties are present. Counsel for the respondents file a counter affidavit in the present case, which is taken on record.
We have endorsed it, Your Lordship, the courtmaster has endorsed it, we are filing it
Okay.
through the center.
Which is taken on record,
Yes.
right?
Yes,
The counsel for the respondents is permitted to file counter affidavit during the course of the day.
Yes.
The counsel for the petitioner submits that the matter be posted tomorrow. Post tomorrow. Next. Next call करिए.
Item 17, WPS 257 of 2023.
Yes, petitioner.
This notices have been issued to the copy number 123 on these 2010.
Have they appeared?
Your Ladyship, I am appearing, Your Ladyship. Wakalatnama has been received today itself.
On behalf of?
Respondent number 1, 2, 3, all the respondents, Your Ladyship. Counter will be filed by 3 weeks.
WPS number 257 of 2023. Counsel for the parties are present. Mr.
Piyush.
Mr. Piyush submits that he has received instructions to appear on he has received wakalatnama to appear on behalf of respondent number 1, 2, and 3.
It will be filed tomorrow.
He shall file the counter affidavit by the wakalatnama by tomorrow and the counter affidavit by next Monday.
3 weeks.
3 weeks.
स्टेट ऑफ महाराष्ट्र में
महाराष्ट्र में जाना पड़ेगा क्या आपको स्टेट ऑफ महाराष्ट्र में? Then once you receive wakalatnama, you receive everything, don't you?
Your Ladyship files एक बार.
Okay, by 19th. By 19th you file. 3 weeks नहीं हो सकता. By 19th, post this case on 21st. चलो. Next.
Item 18, WPS 1979 of 2023.
This counter has not been filed.
Counsel for the petitioner is absent. Okay. How much time do you need?
3 weeks, Your Ladyship.
Counsel for the parties are present.
नहीं फाइल में कुछ नहीं है.
Counter affidavit has been filed.
I apologize, Your Ladyship. I don't have the copy of the counter here.
आप ले लीजिए भाई. इसका रिजॉइंडर फाइल करना है क्या करना? हाँ?
रिजॉइंडर में फाइल.
क्या मैटर है?
Matter है for appointment as member of the district consumer forum.
Member of district consumer forum. Mandamus होगा यहाँ से.
हाँ mandamus. In view of the
ऐसा आप क्या किए कि यहाँ से mandamus होगा?
In view of the observation passed by the summer court in earlier writ petition filed by the
Let's
petitioner.
counsel for the parties submit that the pleadings are complete. Pleadings are complete?
Yes.
I'll reconstruct the file, Your Ladyship. I don't have the copy of counter. That's why
You
I was
take
placing.
आप दे देंगे ना उनको? हाँ. Post this case on 13th of February 23. 13th February 2023. In the meantime, the councils shall file their short list of dates, synopsis of argument, and the judgments which they seek to rely upon prior to the next date of hearing. Next.
Item 20, WPS 2543 of 2023.
Petitioner, counter filed. Counter has been filed. Rejoinder.
Yes, pleadings are complete. We have filed rejoinder also, and we have also filed an IA.
IA for what?
IA for reserving one post in the appropriate category vacant because the prayer is relating to.
Not required. Pleadings are complete.
Pleadings are complete. I will be praying only.
Same order. 13th. 13th, you file your synopsis, list of dates, etc.
Yes.
We'll take up on 13th. Next.
Item 21.
13th की जगह 20 तारीख को रखते हैं. 20 तारीख को. चलिए next.
Item 21, WPS
Same order
299 of
रहेगा
2023.
देखिए एडवांस में फाइल करिएगा written submissions. I will not take it across the board because I need to read it.
The student has been already filed the counter.
Okay, what is the matter about?
Matter which
Tell us what is the matter.
matter lordship, petitioner applied for the post of constable, but he was qualified to be thereafter he appeared in PET examination and he disqualified as a height in the height by measuring of 169.
So what is your right? You were disqualified, isn't it?
But prior to this I have applied 2 times. Page number lordship 50.
And your height was something else.
Yeah. My height is.
Who is for the respondent?
What?
Counsel for the petitioner is present. Nobody appears on behalf of the respondents. The learned counsel submits that the counter affidavit has been filed. Rejoinder filed?
No, lordship.
Not required?
No.
Okay, the counsel submits that. Counter affidavit has been filed. No rejoinder is required to be filed in the present case. He submits that the matter be posted tomorrow. Kal. Chaliye next. Next call.
Item 22, WPS 3823 of 2023.
Petitioner is there. Counter filed. The counter affidavit has been filed in the present case. Time till 19th is granted to the petitioner to file a rejoinder, if any, post on 21st. Next.
Item 23, WPS 4886 of 2023.
Counter filed. Counter affidavits have been filed in the present case. Time till 27th February is granted to the petitioner to file rejoinder, if any, to the counter affidavits. Post on 28th of February.
Item 24, WPS 533 of 2023.
Ladyship, this is for the advertisement for appointment of member in District Consumer Forum.
That will come tomorrow.
Yes, Your
Counter
Ladyship,
affidavit
counter
filed?
has been filed.
Counter filed?
Counter filed.
It's not there.
Counter to file.
Counter filed? Check करिए. WPS number 5443 of 2023. Counsel for the state submits that counter affidavit has been filed in the present case, but the same is not on record. Post tomorrow. कल आ रहा है ना consumer court? Counter not filed. लिखिए लाइए दीजिए. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 20th of February 23, post on 21st.
Item 25, WPS 5634 of 2023.
One counter has been filed by the respondent number 3, Water Resources Department. But a counter is required from respondent number 2, Department of Personnel, because the order which is impugned, that is issued by Personnel Department, and in that counter also they say.
Madam Pinky Tiwari, respondent number 2 in this case has to file a counter affidavit. Counsel for the parties are present. Counsel for the petitioner submits that respondent number 3 has filed a counter affidavit in the present case, but the counter affidavit from respondent number 2 is required. Counsel for the state is directed to seek instructions and file a counter affidavit on behalf of respondent number 2. Let the counter affidavit be filed by 27th February, post on 28th of February. Check next call.
Item 26, WPS 5064 of 2023.
Anybody appearing?
Counter is required to file.
Not filed. WPS number 5664 of 2023. In spite of order passed by this court, counter affidavit has not been filed. Let the counter affidavit be filed by 13th of February. By 15th of February, post this case on 19th. Next.
Item 27, WPS 5769 of 2023.
Petitioner.
Earlier it was directed to file counter, but not yet filed.
Who is for the respondent? State? University, state, sublocal. You inform the councils?
Yes, Your Ladyship.
Will you do that? Sure.
I will inform. Yes, Your Ladyship.
Because they are not there, I don't want to record their
Higher
absence.
education.
Same order, huh? Counter affidavit has not been filed, Kala. Chलिए next.
Okay.
19.
Item 28, WPS 5801 of 2023.
Petitioner. Counter filed. In spite of order passed by this court, no counter affidavit has been filed. Let the counter affidavit be filed by 15th of February, post this case on 19th. Next.
Item 29, WPS 6040 of 2023, along with Item 30.
Pleadings complete
Counter has been filed, but I need to file rejoinder.
in both the cases.
Ma'am?
In both the cases. There are two cases with
Only 29 are
Notice भी हुआ
30 में कौन है?
somebody else.
Okay. WPS notice भी हुआ था? Notice
29.
served?
Notice
must
served
have
and
been
then counter also they have filed no date for yesterday.
WPS number 6040 of 2023 with WPS number 6567 of 23. Learned counsel for the petitioner in 6040 of 23 submits that a counter affidavit has been filed in the present case and prays for and is granted time till
2 weeks.
Time till 19th of February 24 to file a rejoinder to the counter affidavit. Let the pleadings let the required affidavits be filed in the other connected case, that is WPS number 6567 of 2023. अब तक का टाइम दिया 19 तक का टाइम दिया ना. Post this case on 27th. हो गया?
Yes.